And you're going to take that $45,000 a year and stack it on top of whatever that beneficiary makes in that tax year. Daniel from Bryant is next. I am 68 years old, do not own any real estate. I am divorced and have 2 adult children. I'm on Social Security and have approximately $900,000 invested. I feel like I'm missing something. Besides a will and healthcare directive, do I need to add a revocable trust? Well, Johnny mentions he doesn't own any real estate. The $900,000 invested, where that is, also comes into play on whether he needs a trust as well.
Yeah, absolutely. Let me first very clearly state that we're not attorneys, so don't take anything we say on this show as legal advice, because that's not the business that we're in. But we can help to explain some things. So let's talk about a revocable trust and what a revocable trust can do. It serves the purpose in most cases of avoiding probate. Probate is a legal process for a dispensing of your estate. If you die without a will, or even if you die with a will, it goes to probate. If all of your assets are in a trust, then that bypasses probate and is settled through the process of settling the estate through the trust. And so it might not be necessary if this money is in a qualified plan. Now, let me explain. A qualified plan has a beneficiary. You should name your children as beneficiaries if that's where you want that money to go. That's what we would advise anyone, that you can designate a beneficiary and that money goes directly to them. It does not have to go through probate or anything of that nature. It just passes directly to them. So that is a probate avoidance technique. Now, if this money is in a non-qualified account, meaning a non-IRA 401k type account, then that is a completely different story. There may be issues of putting this money in a trust that you want to protect it in some way. And if you want to control the distribution of that money to the next generation, if you want to parse that out over time, if you don't want them inheriting all $900,000 all at once. It's all their money, but the trust can control from the grave how that money is dispensed. The problem, Scott, in a qualified account is you can't really do that because there is something called the Secure Act and the 10-year rule that applies for non-spouse beneficiaries.
Yeah, so a non-spouse beneficiary defined in most cases as 10 years or more younger than the deceased owner of the account. If that is where that money goes, then it is now, as of 2020, when the Secure Act went into law, required to be withdrawn over a 10-year period. It didn't previously have to be that way. The new owner of the beneficiary IRA could pull pieces of that out based on their life expectancy. Now, the government requires that it come out in 10 years. So if you have $900,000, Daniel, in a qualified account like an IRA, and you pass away and you have a sole beneficiary, and it's your child, and in your case, it's not going to your spouse because you're divorced. He says he has 2 adult children. So in that case, $450,000, if both adult children were the beneficiaries, would split $450,000, and that would have to come out over a 10-year time frame. So you think about what that does to your kids. If you passed away relatively soon, they're probably close to 50 years old and probably in their highest working years, and they're probably not wanting a big tax bomb. Back to that that question we had just a moment ago, right? But now they're going to have to take out an RMD, a minimal amount along the way, and have it all cleaned out in 10 years. So the best you could do is piece that out 1/10, 1/10, 1/10, which is about $45,000 a year, and could be more if there's growth in the investments in that account. And you're going to take that $45,000 a year and stack it on top of whatever that beneficiary makes in that tax year. So you can imagine what that might do. Where tax brackets are now, it could jump them from a 24% federal to a 32% federal tax bracket with at least some of those withdrawals. So it is a big, big tax bomb waiting for the next generation, and planning needs to be done. And I think a withdrawal strategy while he's still alive, while Daniel is still alive, makes sense because you can still keep it. You don't have to spend it, but you can put it in different investment vehicles that don't have those same rules attached, John, and allow your child not to be hammered tax-wise.
Yeah, Scott, I have to believe, we were talking politics earlier, I have to believe when the impact of the Secure Act begins to hit the baby boomers' children, there is going to be wailing and gnashing of teeth about how much tax they're paying on their parents' IRA accounts after they inherit them. I know that we recently lost a client who has $1,500,000, and that client has a child as a beneficiary. Well, guess what? $1,500,000 is going to hit that child's taxes sometime in the next 10 years. And and that child, I happen to know, has pretty good income right now. So hello, top tax bracket. That's kind of where that may be going. So I think that's really a critical question that you got to look at. But we've kind of varied off of this for just a second. I want to go back to the trust question, because a trust, assets held in trust bypass probate. It never sees the light of day as far as a probate court is concerned. The probate situation can be expensive and time consuming, and it really exposes all of your personal information to public scrutiny. It really does say, oh, well, you can go to the courthouse and look up what old Joe had, because that's going through probate, and you can see it's a public record. If you have a trust, it is not a public record. It is a private transaction that happens before you pass away of putting your assets in that trust. The qualifier here is that you can't put IRA assets. It can't be owned by the trust. Now, it can be beneficiarized to the trust, but that 10-year rule still applies as far as distribution is concerned.